Hello friends, in the series on income tax cases, today we will discuss a very important issue which is based on a concept that whether the assessee has a right to claim a new claim in the section 147 proceedings, especially in a case when already the assessee has not claimed that claim in the earlier proceedings of section 143 subsection 3, or whether the section 147 proceedings are only for the benefit of the revenue. This issue has been taken up by Bangalore iiiad C bench in the case of Deputy Commissioner of Income Tax versus Navodaya Education Trust, and this case is reported in 129 ITR Tribunal at page number 109. The date of the judgment is 6th April 2023. In the present case, the assessment year is related to assessment year 2009-10. The assessee has filed as a return under section 139 subsection 4C as an education institution, and when the assessment was completed under section 143 subsection 3 of the assessee didn't claim the exemption under section 1023C in that proceedings under section 143 subsection 3. After that, the proceedings under section 148 was initiated against the assessee and some additions were made. When the matter was before the CIT appeal, the assessee raised a additional ground at the time of the CIT appeal that the assessee is entitled to section 1023C exemption, and the CIT appeal allowed that claim to the assessee by saying that the assessment of the assessee should be completed by keeping in view the first proviso of section 143 subsection 3, and that will be applicable to the assessee and not the third proviso. The revenue challenged this ground, order of the CIT appeal before the tribunal, and it was the contention of the revenue that there is no scope for assessee to make additional claim in section 147 proceedings, and it was the ground of the revenue that there was no jurisdiction with the AO or the CIT appeal to entertain the new claim in section 147 proceedings, because it was the contention of the revenue that the section 147 proceedings are only for the benefit of the revenue. When the tribunal heard the matter, the tribunal said that in reassessment proceedings, it is not open to an assessee to seek a review of the concluded item unconnected with the escapement of income, meaning thereby that if the assessment is already completed and some items have been completed in that assessment, then the assessee cannot raise those claims again in the reassessment proceedings. Friends, in this case, the tribunal has relied on the judgment of Commissioner of Income Tax versus Sun Engineering Works Private Limited 1992, which is reported in 198 ITR at page number 297. Friends, as a author, my viewpoint on this case is that the tribunal was very much justified in quashing the order of the CIT appeal and remanding the matter back to the CIT appeal to decide on the merits, because the learned CIT appeal has erred in entertaining the new claim of the assessee by an additional claim. So in this case, if the facts have been different, that if the assessment under section 143 subsection 3 has not been completed, then in that case the assessee can raise any claim, because in the case of Sun Engineering, the word used is reassessment, meaning thereby that the assessee cannot claim a new claim in reassessment. But if the assessment is happening for the first time, that is the section 143 subsection 3 assessment has not been done earlier, then in that case the assessee can raise a new claim. Friends, this case is very important, and the assessee should try to keep this case in mind, that in the reassessment proceedings the assessee is not open to play in new innings for the matters which are already concluded in the original assessment under section 143 subsection 3. But for the item for which the reassessment proceedings have been opened, for that the assessee can claim any expense or deduction. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Navodaya Education Trust, and this case is reported in 129 ITR Tribunal at page number 109. The matter has been decided by Honorable Bangalore iiiad C bench, and the date of the judgment is 6th April 2023. Thank you, friends.